Move that. Yeah, so basically the big news of the day was Pat King, who has been in pretrial detention since February 18th. That is now February to March to April to May. 18th to the 31st is 2 weeks. That's 3.5 months in pretrial detention on mischief charges. Was apparently on the docket today for a bail hearing or a rehearing. And it's a Zoom link. You can open to the public, but you cannot, publication bans on any given trial aside, you cannot reproduce any portion of a court hearing. As far as I understand, I mean, in Canada, I think it's period. In the States, when they're broadcast, obviously you can rebroadcast or comment or share clips. But when they're, despite being open to the public, you can't record in a courtroom. You can't take pictures in a courtroom. You can't audio, whatever. And so the idea being that even when you have access to them through the new technology, Zoom, what are the other ones? Zoom, that other meeting space thing, that you can view them remotely, but you cannot rebroadcast them or take screenshots. You can't do remotely what you would not have otherwise been able to do in person in the courtroom. So even though you can access these things, you can't screen grab, rebroadcast, live stream, commentate, as some people discovered during one of the previous, I think it was one of the previous Pat King bail hearings. So Pat King was up for a bail hearing today. You could tune in by Zoom, and everyone should do it. If you can find the link, you should tune in, if not necessarily for Pat King, for anybody, just to understand how the court system actually works, to see it firsthand. Because I never practiced criminal law. It's still interesting to the extent you're dealing with real people who are behind bars, and the human element. It's, it can be nauseating or distressing. But let me see here in the chat. But it's interesting to listen to, because people don't appreciate. Some people say, I like law, but I don't want to study procedure. I'd say like 90% of the practice of law is procedure. Let's just say maybe 80. The majority of the practice of law is procedure. It's not every day that you argue the substance of the law. More often than not, you go to court for scheduling, for strategizing for the purposes of scheduling, for strategizing for the purposes of specific questions that are going to be before the court that day. And it's more procedure than anybody knows. And so you go listen to this, where you think it's going to be a bail hearing. You're going to be arguing the merits of the case for 2 days like you did with Tamara Litch. You get there and you hear what's on the docket. The docket is basically the schedule of the day, the list of the day of the cases before the court. Today, I think Pat King came up third to last. So I think Pat King came up 17th on the docket. They went through 16 separate cases of individuals accused for various reasons. And you see the judge, the clerk, the counsel, the prosecutor, they're trying to figure out which line of the docket a specific case is on, so they can know the names of the parties and the nature of the case. So they go through and say, okay, we're on the parties, Crown versus whomever. What number of the docket it is, so we can see what the nature of the case is, what the state of the proceeding is, because the docket will have all the information of the case up until that date. Some people were arrested over the weekend. Some people have been detained for weeks. Some people can't get in touch with their counsel. A lot of the defendants who don't actually have counsel are self-representing and appearing remotely as well from court. And so you go through, I know, who's this guy? What's he? Okay, what do you want? Well, we're going to postpone 2 weeks so that defense and the Crown can discuss terms of bail. Then you hear some individuals, the actual accused, fighting with their counsel because they're, I don't know what's going on. I've been here all weekend. I can't get in touch with you. Some of them are self-represented, don't understand that they're only there for scheduling or procedural stuff, not substantive stuff. At one point during the bail thing today, one of the defendants started, talking about the substance of his accusations. And the judge don't say anything here. What you say can and will be used against you. We're here for scheduling, for procedure. Don't get into the substance of your defense on the substance of the accusations. And so we went through 17 of those cases. You hear stagiaires, interns, coming there for court and saying, yes, my name is X and Y. I'm here as an intern or stagiaire from this law firm. We'd like to postpone for yada, yada, yada. So it went on for 9:30 to 11:30. They went through 17 cases, finally got up to Pat King. Pat King, identify yourself, date of birth. And I think it was his counsel that said, we want to postpone 2 weeks so that we can continue discussions with the Crown on pre-trial hearings and bail terms or a bail rehearing. And that's it. You wait there all morning listening to the court. Pat King comes in, 2 minutes, postpone 2 weeks. And now it goes to, I think I tweeted it was June 13th. Let me just make sure that I did that. It was June 13th is going to be, I think it's a pre-trial conference or a bail hearing. I didn't exactly understand. June 14th. And the court mentioned there's a publication ban in Pat King. I don't know what the purpose of the publication ban is, but from my understanding, it was Pat King and the defense that asked for it, not the prosecution. John, a gin bottle. Viva, I believe everyone should serve out their time pretrial. No bail. What do you say? I don't know if that... Everyone should serve out their time pretrial. No bail. I don't know if that's sarcastic or ironic or parody, because that would violate every presumption of criminal law that we have. It would violate rules of habeas corpus. It would violate rules of innocent until proven guilty. It would violate rules of unlawful detention. So I think that's a joke. And in which case, if it is, well played. Everyone has to appreciate pretrial detention is detention of an individual who, legally speaking, is innocent. You may think they're guilty. There may be lots of indications that they are in fact guilty, but pretrial detention is detention in prison, deprivation of life, well, not life, deprivation of liberty of someone who is, legally speaking, innocent. They have not been convicted in a court of law. So if you're going to pretrial detain someone, or if you're going to detain someone pretrial, if you're going to violate their most fundamental civil rights and liberties, you need to have the bestest of the excuses to do so. And those excuses, as fleshed out in case law and in our legal system, flight risk, because if you think someone's going to flee and they're not going to show up for their trial, and you have to have compelling evidence for that, that's a reason to deprive them of their constitutional rights of life, freedom, and mobility. Extreme risk to the public. You take an individual, hypothetically, an individual who runs over 4 protesters with his or her vehicle. You know, the risk that an individual like that might pose to society at large, if released, could be substantial enough that in the minds of some, you could argue for pretrial detention. Because if you release them, they are going to pose an immediate risk to either the victim, either some witnesses, or the public at large. And even then, it's got to be compelling. There was another issue. There was one, recidivism, risk to the public. Oh, and there's a concept called impugning. It is called impugning the administration of justice, or it's basically undermining. Would releasing the individual compromise the integrity of the judicial system in the eyes of the public? You know, some people are accused of such heinous crimes. There's an orgy of evidence upon their arrest that if you release them, it would undermine people's confidence in the judicial system. This, incidentally, is the argument that one of the previous justices of the peace used to justify the pretrial detention of Pat King. Listen to this twisted Kafkaesque carriage in front of the horse logic. The officer of the peace in Pat King's bail hearings, the ones that have resulted in him being detained now for 3.5 months. Same logic actually with Tamara Lich as well. The initial officer of the peace or justice of the peace who ordered the pretrial detention of Pat King, who's accused of mischief-related charges, said this man orchestrated a protest, not an insurrection, but an occupation, encouraged people to participate in this illegal protest. Says the second I get out, I'm going to go back and tell people to go protest. To release him would, someone's got to get the word for me. I'm going to go crazy. Would impugn the administration of justice. To release him would undermine the public's faith in the legal system. Hence, we're going to lock up in pretrial detention a man who is legally innocent on charges of effective mischief-related charges. And when I say that that is Kafkaesque, Orwellian, carriage in front of the horse, I don't think most people would say continuing to detain this individual who was arrested on non-violent mischief charges would continuing to, I'm not convinced that most people would say, if you release this person, I will lose faith in the judicial system. I think it's the exact other way around. I'm losing faith in the judicial system by continuing to witness the continued pretrial detention of someone who I don't think is an immediate threat to anybody. He might have caused some mischief. I don't think he's an immediate threat to anybody. I don't think he's a flight risk either. And there are ways to mitigate flight risks such that even the release could curtail the risk that he's going to hop on a plane, which I don't think he's going to do for, logistical reasons, policy reasons in Canada. I don't think this dude's hopping on a train or a plane to fly to a country that does not have extradition for mischief charges. There are ways to mitigate that. But my personal opinion as a lawyer, although the only opinion that matters is that of the judge, it would not be the release of this individual that would undermine people's faith in the judicial system. It's the continued pretrial detention of Pat King, who is innocent until proven guilty in a court of law on mischief charges. That is undermining my faith in the judicial system more than the release and more than anything that occurred in the 3 weeks of that Ottawa protest. That is what is undermining my faith in the Canadian judicial system in a meaningful, substantial, and I might even say permanent way.